All right, so get ready for another deep dive. This time, into criminal law. You guys have sent over a ton of legal documents, specifically excerpts from Criminal Law Part 1.
Uh-huh.
And it looks like we're going to be focusing on the fundamentals.
Okay.
The theories, principles, even some concepts from the revised penal code of the Philippines.
Right.
Whoa, there's a lot to unpack here, but that's what we do.
Yeah. You know, what's fascinating about this stuff is it offers a glimpse into how, legal systems grapple with human behavior and the idea of justice,
For sure.
It's really
Absolutely.
interesting.
Okay, so our mission for this deep dive is to break down these legal concepts, find the most intriguing bits, and then figure out why these principles matter, not just in the Philippines, but for understanding legal systems worldwide.
Exactly. And a good starting point would be exploring the different theories of criminal law.
Okay.
They're outlined in your sources. There are 4 main schools of thought: classical, positivist, eclectic, and utilitarian.
So it's like different lenses through which we view crime and punishment?
Precisely. Each theory offers a different perspective on why people commit crimes and what the purpose of punishment should be.
So let's start with the classical theory, since you mentioned it heavily influences the Philippine Penal Code.
Right.
What's the core idea there?
Well, the classical theory emphasizes free will.
Okay.
It assumes that individuals have the capacity to make rational choices.
Right.
And when they choose to do wrong, they should be held responsible for their actions. Punishment, in this view, is primarily about retribution.
Okay.
Like a sort of balancing of the scale.
That eye for an eye concept.
Exactly. The severity of the punishment should be proportionate
Okay.
to the severity of the crime.
That makes sense.
Yeah.
But what about factors beyond a person's control that might influence their behavior? Does the classical theory take that into account?
That's one of the main critiques of the classical theory, actually.
Okay.
It can be seen as overly simplistic in its view of human behavior,
Okay.
not fully accounting for social, economic, or psychological factors
Right.
that might contribute to criminal activity.
So where does the positivist theory come in?
Well, the positivist theory offers a contracting perspective.
Right.
It sees criminal behavior as largely determined by factors outside an individual's control,
Okay.
such as poverty, upbringing, or mental illness.
So less about free will and more about understanding the underlying causes of crime.
Precisely. From a positivist perspective,
Okay.
the focus of the justice system should be on rehabilitation and preventing future crime, rather than simply punishing past transgressions.
That sounds more humane.
Yeah.
Like more focused on addressing the root of the problem.
It does have that appeal.
Okay.
However, the positivist theory also has its critics.
Okay.
Some argue that it can downplay individual responsibility and potentially lead to overly lenient treatment of offenders.
So again, it's like a balancing act, like so much in the legal system.
Exactly.
What about those other 2 theories that you mentioned?
Okay.
Eclectic and utilitarian.
Well, the eclectic theory, as the name suggests, draws from both classical and positivist ideas,
Okay.
recognizing that criminal behavior is complex
Right.
and influenced by a combination of individual choices and external factors.
Okay.
So it seeks to tailor the response to the specific circumstances of each case.
So more nuanced approach.
Exactly.
Trying to find the right balance between punishment and rehabilitation.
Exactly. And then there's the utilitarian theory,
Okay.
which focuses on the overall benefit to society.
Okay.
It views punishment as a means to deter crime and protect the public, even if it means sacrificing individual rights in some cases.
Well, that sounds a bit harsh.
Yeah.
Prioritizing the needs of the many over the needs of the few.
It can be a controversial approach, as it potentially justifies harsh punishments or even the imprisonment of innocent people
Right.
if it's deemed necessary to prevent a greater harm to society.
It's like that classic ethical dilemma.
Yeah.
Right. The trolley problem.
Yeah.
Do you sacrifice one life to save many?
That's a great analogy.
Yeah.
The utilitarian theory wrestles with those kinds of moral dilemmas,
Right.
trying to find the greatest good for the greatest number of people.
Okay, so we've got these 4 main theories, each with its strengths and weaknesses.
Uh-huh.
Where does the Philippine Revised Penal Code fit into all of this?
Well, your sources indicate that the revised penal code primarily follows the classical theory,
Okay.
emphasizing individual responsibility and retribution.
Right.
However, it also incorporates elements of the positivist theory,
Okay.
recognizing that certain factors like age or mental capacity can affect a person's culpability.
So it's not a pure classical approach.
Yeah.
There's some blending of philosophies happening.
Exactly. It reflects the evolving nature of legal systems, trying to find a balance between competing theories and adapt to changing societal norms.
Okay, so we've laid the groundwork with the different theories of criminal law.
Uh-huh.
Now, let's get into some of the specific principles and concepts outlined in these documents.
Okay.
One that stands out is the principle of pro reo, which means in favor of the accused. It's a fundamental principle in many legal systems,
Right.
including the Philippines.
Yes.
What's the idea behind that principle? Why would the law favor the accused?
It stems from the presumption of innocence,
Okay.
which is a cornerstone of a fair and just legal system.
Okay.
The burden of proof is on the prosecution to prove guilt beyond a reasonable doubt. If there's any doubt, the law errs on the side of caution, favoring the accused.
It's like that saying, it's better to let 10 guilty persons go free than to convict one innocent person.
Exactly. The principle of pro reo reflects a deep-seated societal value, protecting individual liberty and ensuring that the legal system isn't used to unjustly punish the innocent.
That's a powerful concept.
Yeah.
It reminds us that the law isn't just about punishing wrongdoers. It's also about safeguarding individual rights
Yeah.
and ensuring fairness.
Precisely.
Yeah.
And it highlights the importance of due process, the right to a fair trial,
Right.
and the need for evidence-based convictions.
So pro reo isn't just a legal technicality. It's a reflection of our commitment to justice
Yeah.
and individual liberty.
Well said. It's a principle that has evolved over centuries,
Right.
often in response to historical injustices and abuses of power.
It makes you appreciate how much thought and history have gone into shaping our legal systems.
It really does.
Now let's move on to another key principle,
Okay.
NULLUM CRIMEN, nulla poena sine lege.
Right.
You mentioned this earlier.
Yes, it's a Latin phrase that essentially means no crime without law, no punishment without law. It's a fundamental principle of legality, meaning that individuals can only be punished for acts that are clearly defined as crimes by law.
So you can't just make up crimes as you go along.
No.
There has to be a pre-existing law
Yes.
prohibiting the specific act.
Exactly. This principle prevents arbitrary or retroactive punishment,
Right.
ensuring that everyone knows what's considered criminal behavior and what the potential consequences are.
So it creates a level playing field.
Uh-huh.
Right. Everyone is subject to the same set of rules.
Yes.
And those rules have to be clearly defined and accessible.
Precisely. It's about transparency and fairness in the legal system. Individuals should have fair notice of what's prohibited so they can make informed choices about their behavior.
And this principle also protects against abuses of power, right?
Absolutely.
It prevents those in authority from arbitrarily punishing people they don't like
Yeah,
or targeting specific groups without just cause.
absolutely. Nullum crimen, nulla poena sine lege, is a cornerstone of a society governed by the rule of law, where power is constrained by legal principles and everyone is held accountable to the same standards.
So it's not just a legal concept, it's a fundamental principle of a free and just society.
Yes. Yep.
It's about ensuring that the law is applied fairly and impartially, protecting everyone's rights.
Well said. It's a principle that has been hard-won throughout history and continues to be a vital safeguard against tyranny and injustice.
It makes you appreciate those who fought for these principles, who recognize that a just society
It does.
requires clear laws and fair procedures.
Absolutely.
Now, let's move on to another interesting concept outlined in your sources.
Yep.
The distinction between mala in se and mala prohibita.
This distinction goes to the heart of what we consider inherently wrong versus what's wrong, because society has deemed it so.
Go break it down for me.
Okay, mala in se literally translates to evil in itself.
Okay.
These are acts that are considered inherently immoral or wrong, regardless of whether there's a law prohibiting them.
Okay.
Think of acts like murder, theft, or rape.
Universally condemned.
Exactly.
Yeah.
Across cultures and throughout history, those acts have been recognized as harmful and wrong.
Right.
The inherent wrongness of these acts is often rooted in concepts like natural law or universal moral principles.
So it's not just about what the law says.
Right.
It's about a deeper sense of right and wrong.
Yeah.
Okay, what about Mala prohibita.
Mala prohibita means wrong because it's prohibited.
Okay.
These are acts that are considered crimes because the law says so.
Right.
Not because they're inherently evil or immoral.
Okay.
Think of things like traffic violations, gambling, or violating certain business regulations.
So it's about society setting rules and boundaries, even if those rules don't necessarily reflect some universal moral code.
Exactly. Mala prohibita crimes are often about maintaining order,
Okay.
promoting safety, or regulating specific activities.
It's like saying, look, we need some rules of the road here.
Yeah.
Even if driving on the left side versus the right side is somewhat arbitrary.
Right.
It's about everyone being on the same page.
That's a great analogy. It's about creating a predictable and orderly society.
But this distinction seems like it could get a bit blurry sometimes, right? What about something like drug use?
Yeah.
Is that inherently wrong? Or is it wrong because society has decided to prohibit it?
That's a great example of how the line between mala in se and mala prohibita can be debated.
Huh?
Some might argue that drug use is inherently harmful and therefore mala in se, while others might argue that it's a victimless crime that's only wrong because it's prohibited by law.
So again, these categories aren't always clear-cut.
Yeah.
There's room for interpretation and debate.
Absolutely. And societal values can shift over time, leading to changes in what's considered mala in se or mala prohibita.
Right.
Think of things like alcohol prohibition or the changing laws around marijuana use.
It's fascinating how the law reflects these evolving societal values. But this distinction between mala in se and mala prohibita seems like it has practical implications. Right. It affects how crimes are prosecuted and punished.
You're right. One key difference is the role of intent.
Oh.
For mala in se crimes, proving criminal intent, often referred to as mens rea, is usually essential for a conviction.
So if you accidentally kill someone, it's not necessarily murder.
Exactly.
Right. Depends on whether you intended to cause harm.
The law recognizes that accidents happen,
Right.
and it distinguishes between intentional acts and unintentional ones.
But for mala prohibita crimes, intent might not matter as much, right?
That's generally the case.
Okay.
For many mala prohibita offenses, the focus is on the act itself, not the intent behind it.
Okay.
Think of traffic violations.
Right.
If you're caught speeding, it doesn't matter if you were late for work or just didn't notice the speed limit sign.
Right.
You broke the rule and you face the consequences.
So with mala prohibita crimes, it's more about upholding the law and ensuring compliance, even if there wasn't any malicious intent.
Precisely. It's about maintaining order and predictability.
Okay, that makes sense.
Yeah.
But this whole discussion of intent brings us to two other important legal concepts outlined in your documents: actus reus and mens rea.
These Latin terms are at the core of criminal law, representing the two essential elements that must typically be proven for conviction.
Okay, give me the Latin lesson.
All right.
What do those terms mean?
Okay, actus reus refers to the criminal act itself, the guilty act.
Okay.
It's the physical element of the crime, the actual doing of the prohibited deed.
So the action, the behavior.
Yeah.
The thing that's actually forbidden by law.
Yes.
Okay, what about mens rea?
Mens rea refers to the criminal intent, the guilty mind.
Okay.
It's the mental element of the crime.
Okay.
The state of mind that accompanies the act.
So it's not just what you did, but why you did it. What was going on in your head at the time.
Yes. For most crimes, both actus reus and mens rea must be present for a conviction.
Cool.
You have to commit the prohibited act and have the requisite mental state while doing so.
Can you give me an example to illustrate how this works in practice?
Certainly. Let's consider theft.
Okay.
The actus reus of theft is the taking of someone else's property without their consent. But the mens rea is the intent to permanently deprive the owner of their property.
So if I borrow my neighbor's lawnmower without asking, but fully intend to return it, that's not technically theft.
Exactly. You committed the actus reus, taking the property without consent, but you lack the mens rea, the intent to permanently deprive the owner of their property.
Okay.
It might be considered trespassing or borrowing without permission, but not theft in the legal sense.
So it's the combination of the act and the intent
Yes.
that determines whether a crime has been committed.
Yes.
That's a really important distinction.
It is. And it highlights why criminal law can be so complex.
Proving intent can be tricky.
Yeah.
as it often involves relying on circumstantial evidence or inferences from a person's actions.
It's like trying to get inside someone's head
Right.
and understand their motivations.
Exactly. And that's why criminal trials can be so fascinating.
Right.
They're not just about proving what happened, but about understanding why it happened.
Yeah.
And whether the accused person had the requisite mental state to be held criminally liable.
This is all starting to make a lot more sense. We've gone from broad theories of criminal law to the specific elements of a crime, like actus reus and mens rea. It's like we're building a foundation for understanding how the legal system works.
That's a great way to put it. We're laying the groundwork for exploring the intricacies of criminal law.
Okay.
And the fascinating scenarios it addresses.
Speaking of fascinating scenarios, what's next on our journey through these legal documents?
Let's delve into the cardinal principles of criminal law.
These principles outline the scope and limitations of criminal law, determining where and to whom these laws apply.
Okay.
It gets into some really interesting questions about jurisdiction, sovereignty, and the reach of legal systems.
Sounds intriguing. I'm ready to dive in.
Let's do it. Welcome back to our deep dive into criminal law. Ready to continue unpacking these legal concepts with you?
Yeah, me too. We've already covered so much, from the different theories of criminal law to the essential elements of a crime.
Right.
It's like we're piecing together a puzzle, understanding how the legal system approaches crime and punishment.
That's a great analogy. And speaking of puzzles, let's delve into the cardinal principles of criminal law.
Okay.
These principles outline the scope and limitations of criminal law, determining where and to whom these laws apply.
Okay, so it's about setting boundaries for the legal system. Like, where does its authority begin and end?
Exactly. And one of the key principles is territoriality, which means that, in general, Philippine criminal laws apply only within Philippine territory. It's about a country's sovereignty and its right to enforce its laws within its own borders.
That makes sense, but the world is so interconnected these days, with crimes often spanning multiple countries.
Right.
How does the principle of territoriality work in those situations?
Yeah, you've hit on a key challenge for legal systems in the modern era. The internet, globalization, and transnational crime have blurred those territorial lines. But yes, there are exceptions to the principle of territoriality.
I'm all ears. What kind of exceptions are we talking about?
Well, your source mentions the Cybercrime Prevention Act of 2012 as a prime example.
Okay.
This law recognizes that cybercrimes, by their very nature, can transcend physical borders.
Right. A hacker sitting in one country can easily target individuals or systems in another country.
Exactly. So the law has had to adapt to these new realities, extending its reach beyond traditional territorial boundaries.
So does the Cybercrime Prevention Act essentially give the Philippines jurisdiction over cybercrimes committed anywhere in the world? As long as there's, some connection to the Philippines.
It's not quite that broad. The law focuses on cybercrimes committed by Filipino nationals, regardless of where they are physically located.
Okay.
Or cybercrimes committed against Philippine citizens or institutions, even if the perpetrator is outside the Philippines.
So it's about protecting Filipino citizens and interests, even in the virtual realm. Recognizing that harm can be inflicted from afar, even without physically crossing borders.
Exactly.
What other exceptions to territoriality are there?
Another set of exceptions involve crimes committed on ships or aircraft registered in the Philippines. Even if these vessels are in international waters or airspace, Philippine law generally still applies.
Oh, so it's like extending a country's legal jurisdiction to its flag-carrying vehicles wherever they may roam.
Exactly. It makes sense in a way. It's about maintaining order and accountability within those specific spaces.
Right. And then there are exceptions based on international agreements, right?
Yes. For example, the Philippines might have treaties with other countries that allow for the extradition of criminals or the prosecution of certain crimes committed outside Philippine territory.
So it's about countries cooperating to enforce laws.
Right.
And ensure that criminals can't simply escape justice by crossing borders. It creates a more interconnected legal landscape, recognizing that crime doesn't always respect geographical boundaries.
Precisely. And it highlights the growing importance of international law and cooperation in addressing transnational crime.
Okay, so territoriality, while a foundational principle, is not absolute. The law has had to adapt to the realities of a globalized world.
Exactly.
What other cardinal principles are outlined in these documents?
Another key principle is generality, which means that criminal laws apply to everyone within the Philippines, regardless of their nationality, ethnicity, social status, or any other personal characteristic.
So no one is above the law,
Right.
and everyone is subject to the same rules.
Exactly. It's about equality before the law.
Fundamental principle of a fair and just society. But are there any exceptions to this principle of generality?
Um, there are a few exceptions based on international law and diplomatic immunity.
Oh.
For example, diplomats from other countries who are stationed in the Philippines generally enjoy immunity from prosecution under Philippine law.
Okay.
And this immunity is reciprocal, meaning Philippine diplomats also enjoy similar protections when abroad.
So it's about respecting the sovereignty of other nations and ensuring that diplomats can carry out their duties without fear of, being subjected to the laws of the host country.
Exactly.
What about those situations where diplomatic immunity is abused?
Right.
What if a diplomat commits a serious crime in the Philippines? Are they completely untouchable?
That's a valid concern, and there are mechanisms in place to address such situations. The Philippines can request the diplomat's home country to waive their immunity, allowing for prosecution under Philippine law.
Okay.
Or the diplomat can be expelled from the country, essentially ending their diplomatic mission and their immunity.
So there are checks and balances even within the system of diplomatic immunity. It's not a free pass to break the law.
Exactly. And it highlights the delicate balance between respecting international norms and ensuring accountability for criminal acts.
Okay, so we've got territoriality, generality, and their exceptions. What other cardinal principles are there?
The final principle is prospectivity, which essentially means that criminal laws apply only to acts committed after the law has been enacted.
Okay.
Individuals cannot be punished for actions that were not considered crimes at the time they were committed.
So it's about fairness and predictability, right?
Yeah.
People need to know what's considered criminal behavior so they can make informed choices.
Exactly. It prevents the government from arbitrarily changing the rules of the game and punishing people retroactively for actions that were once legal.
It's like saying you can't move a goalpost after the game has already started.
Right, yeah.
People need to know what the rules are from the outset.
That's a great analogy. The principle of prospectivity safeguards individual rights and ensures that the legal system is perceived as fair and just.
But are there any exceptions to this principle of prospectivity?
There's one important exception. If a new law is more favorable to the accused, it can be applied retroactively,
Okay.
even if the crime was committed before the law was enacted.
So if a new law reduces the penalty for a particular crime,
Right.
someone who was convicted under the old law might benefit from the new, more lenient law.
Exactly. This exception reflects the principle of lenity, which means that when there's ambiguity in the law or conflicting interpretations,
Okay.
the law should be interpreted in favor of the defendant.
So it's like giving the accused the benefit of the doubt, recognizing that the law should err on the side of mercy when possible.
Precisely. And it highlights the ongoing evolution of legal systems,
Right.
striving to ensure fairness and adapt to changing societal values.
This deep dive into the cardinal principles of criminal law has been really insightful. It's amazing to see how much thought and nuance goes into defining the scope and limitations of the legal system.
It's a testament to the complexity of balancing individual rights, societal needs, and the pursuit of justice.
Well said. So we've explored these broad principles, but what about the specific circumstances that can affect an individual's criminal liability, even if they've technically committed a crime?
Okay.
I'm thinking of those situations where the law recognizes that someone might not be fully responsible for their actions.
Right. Those are called exempting circumstances.
Okay.
And they're based on the idea that while someone might have committed a prohibited act, they might lack the necessary mental capacity or freedom of will to be held fully accountable.
So it's recognizing that there are degrees of culpability, that not every crime is committed with the same level of intent or awareness.
Exactly. The law recognizes that certain factors can diminish or even negate criminal responsibility, even if the act itself meets the definition of a crime.
Can you give us some examples of these exempting circumstances?
Sure.
What kinds of situations are we talking about?
Okay, let's start with insanity, as defined under Article 12 of the Revised Penal Code.
Okay.
It's a complex legal concept rooted in the idea that someone might be so mentally impaired that they can't distinguish right from wrong or control their impulses.
So it's not just about feeling a bit off or having a bad day.
No.
There has to be a genuine mental illness that significantly impacts a person's ability to understand and control their behavior.
Precisely. The law recognizes that individuals with severe mental illnesses might not have the same level of moral culpability as someone who commits a crime with full awareness and intent.
But proving insanity in a court of law seems like it would be incredibly difficult.
It is.
How do you demonstrate that someone who was truly incapable of understanding the consequences of their actions?
It's a challenging legal task, often requiring expert testimony from psychiatrists or psychologists who can evaluate the defendant's mental state and provide evidence to support the claim of insanity.
So you can't just claim you went crazy after the fact to avoid responsibility.
Right.
It has to be a pre-existing condition
Yes.
that significantly impaired your ability to understand or control your actions at the time of the crime.
Exactly. And the burden of proof is on the defense to establish insanity by clear and convincing evidence.
So it's a high bar to clear.
Uh-huh.
What are some of the mental illnesses that might qualify as insanity under the law?
Well, the revised penal code doesn't list specific mental illnesses, but case law has established that conditions like severe schizophrenia, dementia, or epilepsy that significantly impair cognitive function and judgment could potentially qualify as exempting circumstances.
So it's not just about having a diagnosis, but about how that diagnosis affects a person's ability to function and make rational choices at the time of the crime.
Yeah.
But what about conditions like temporary insanity or being under the influence of drugs or alcohol? Do those count as exempting circumstances?
Those are tricky situations, and the law doesn't have clear-cut answers. Generally, temporary insanity might be considered a mitigating circumstance rather than a complete exemption from liability.
Okay.
It might reduce the severity of the punishment, but not completely absolve the person of responsibility.
So it's like a partial defense. It acknowledges that the person wasn't in their right mind.
Right.
But it doesn't completely excuse their actions. What about being drunk or high?
That's even more complicated. Generally, voluntary intoxication isn't considered an exempting circumstance. In fact, it might even be considered an aggravating circumstance.
Oh, wow.
If it shows a reckless disregard for the potential consequences of one's actions.
So if you choose to get drunk or high, you're essentially taking on the risk.
Yeah.
You might do something you'll regret later.
Right.
The law doesn't offer much sympathy in those situations.
That's generally the case. However, there might be exceptions in extreme cases where intoxication is so severe that it renders the person completely incapable of understanding or controlling their actions, almost like a temporary state of insanity.
So there's some nuance there, but the general rule is that you can't just blame your bad behavior on being drunk or high.
Exactly. You're expected to take responsibility for the choices you make, even if those choices are influenced by substances.
Okay. What other exempting circumstances does the revised penal code outline?
Another important one is minority, which refers to the age of criminal responsibility.
Okay.
Children below a certain age are generally considered exempt from criminal liability because they lack the mental maturity and judgment to understand the full consequences of their actions.
That makes sense. We don't hold children to the same standards of accountability as adults.
Right.
But what is the age of criminal responsibility in the Philippines?
The current law, Republic Act 9344, as amended by Republic Act 10630, sets the minimum age of criminal responsibility at 15 years old.
Okay.
Children below that age are exempt from criminal liability, even if they commit acts that would be considered crimes if committed by an adult.
That seems like a significant shift from the previous law, which set the age of criminal responsibility much lower.
Right.
What prompted this change?
Well, there's been a growing global recognition that children are developmentally different from adults and require a different approach within the legal system. Instead of focusing on punishment, the emphasis for children who commit offenses is on rehabilitation and reintegration into society.
So it's about understanding that children are still developing, that their brains aren't fully formed,
Right.
and that they might not have the same capacity for impulse control or moral reasoning as adults.
Exactly. And there's a recognition that punishing children harshly can be counterproductive, potentially leading to further criminal behavior later in life.
Right.
It's about trying to break the cycle of crime and give young people a chance to turn their lives around.
That's a much more humane and hopeful approach. But what happens if a child below the age of criminal responsibility commits a serious crime?
Right.
Are there any consequences at all?
Yes. Even though they're exempt from criminal liability, children below 15 who commit offenses are subject to intervention programs designed to address the underlying issues that led to their behavior and help them get back on track. These programs might involve counseling, family therapy, educational support, or other services aimed at promoting rehabilitation.
So it's about addressing the root causes and providing support,
Yes.
rather than simply punishing the child. It's a much more nuanced and compassionate approach.
It is. It recognizes that children are still developing and that their actions are often influenced by factors beyond their control, such as poverty, abuse, or lack of access to education.
It's about giving them the tools and support they need to make better choices and become productive members of society.
Exactly.
What other exempting circumstances does the law recognize?
Article 12 of the revised Penal Code also outlines exemptions for those acting under compulsion of an irresistible force or under the impulse of an uncontrollable fear of an equal or greater injury. Essentially, this means that someone might be excused from criminal liability if they were forced to commit a crime against their will, or if they acted out of genuine fear for their safety or the safety of others.
So it's about recognizing that sometimes people are put in impossible situations
Right.
where they have no real choice but to break the law.
Exactly. The law takes into account these extreme circumstances and acknowledges that a person's actions might not be truly voluntary if they're acting under duress or out of genuine fear.
Can you give us some examples?
Imagine someone being forced at gunpoint to rob a bank. They're physically coerced into committing the crime.
Okay.
Or consider someone who helps a criminal escape because they're threatened with harm to themselves or their family if they don't comply.
Right.
Those are situations where the law recognizes that the person's actions, while technically criminal, are understandable given the extreme circumstances.
It's like saying, we understand that you were between a rock and a hard place, and we're not going to hold you fully responsible for actions that were essentially forced upon you.
That's a good way to put it. The law recognizes that human behavior is complex and that sometimes people act in ways they wouldn't otherwise choose if they weren't under extreme pressure or facing a genuine threat.
But like with insanity, these defenses would likely require strong evidence
Yes.
to convince a court that the person was truly acting under duress.
Exactly.
You couldn't just claim you felt pressured to commit a crime
Right.
and expect to be let off the hook.
There has to be a credible and imminent threat that would compel a reasonable person to act in a way they wouldn't otherwise choose.
Right.
The law draws a distinction between genuine coercion and simply making a bad choice.
So there's a high bar to clear. What other exempting circumstances are there?
Another one, though rarely invoked, is accident.
Yeah.
Article 12 of the revised Penal Code states that someone is exempt from criminal liability if they committed an act that would otherwise be a crime,
Okay.
while performing a lawful act with due care and without any fault or intention of causing harm.
So it's about genuine accidents, those situations where someone is going about their business, doing everything right, and something unforeseen and unintended happens.
Exactly. But, like with other exempting circumstances, proving accident would require strong evidence to convince a court that the harm was truly unintentional and that the person acted with reasonable care.
So it seems like the key takeaway here is that the law recognizes that not all criminal acts are created equal.
Mm-hmm.
There are a variety of circumstances that can affect a person's culpability and potentially lessen or even eliminate their criminal liability.
That's a great summary. The law aims to be just, and that involves considering not just the act itself, but also the intent, the circumstances, and the individual's capacity for understanding and control.
Well said. It's fascinating to see how the law tries to account for the complexities of human behavior and the various factors that can influence our actions.
It's a testament to the ongoing evolution of legal systems, striving to find a balance between upholding the law and ensuring fairness and compassion in its application.
This deep dive into the Philippine Revised Penal Code has been incredibly insightful. We've covered so much ground, from the broad principles of criminal law to the specific circumstances that can affect an individual's liability.
Right.
It's amazing how much nuance and complexity there is to this area of law.
It's truly a fascinating field, constantly evolving to address new challenges and reflect changing societal values.
Well, we're not done yet, are we?
Okay.
There's still more to uncover in these documents.
Right, we're just getting started.
What other intriguing legal scenarios does the Revised Penal Code address?
In our next segment, we'll delve into some thought-provoking concepts like impossible crimes, the various stages of a crime,
Okay.
and the distinctions between conspiracy and proposal. These concepts really get to the heart of how the law grapples with the complexities of human behavior and criminal intent.
I'm definitely intrigued. I can't wait to explore those concepts further.
Okay, great.
Stay tuned, listeners, for the final part of our deep dive into the Philippine Revised Penal Code. We'll be back soon to unravel more legal mysteries and shed light on the fascinating interplay between law and human behavior. Welcome back to our deep dive into criminal law. It's amazing how much ground we've covered already, from the broad theories of criminal law to those specific circumstances that can affect a person's liability.
Yeah, it's been a fascinating journey. And, the concepts we're about to explore
Yeah.
really highlight the intricacies of how the law tries to anticipate and address every possible scenario, no matter how unusual or seemingly paradoxical.
Okay, you've definitely piqued my curiosity. You mentioned something called impossible crimes
Right.
in the last segment.
Uh-huh.
Those sound like something out of a legal thriller.
They do have a bit of a head-scratching quality to them.
Yeah.
Essentially, an impossible crime is when someone attempts to commit a crime that is, by its very nature, impossible to complete.
Okay, I'm still trying to wrap my head around that. Could you give me some examples?
Certainly. Imagine someone trying to kill someone who's already dead. Or picture a thief attempting to steal from an empty pocket.
Right.
Those are classic examples of impossible crimes.
Okay.
The actions themselves, even if fully carried out, wouldn't result in an actual crime.
So it's like trying to do something that's fundamentally impossible, like violating the laws of physics or trying to alter reality through sheer willpower.
That's a great way to put it. And yet,
Yeah.
the law still considers these attempts to be punishable offenses, albeit with lighter penalties
Right.
than the intended crime itself.
Okay, now I'm really confused. Why punish someone for something that couldn't actually happen?
It might seem counterintuitive, but there are a few reasons why the law takes this approach.
Okay.
Firstly, it's about deterring harmful intent. Even if the method is flawed or the outcome is impossible,
Right.
the fact that someone is actively trying to cause harm is a concern for society.
So it's like sending a message. We're watching, and even if you fail spectacularly, we're still going to hold you accountable for your intentions.
Exactly. It's a way of reinforcing societal norms and discouraging people from even contemplating criminal acts, regardless of how outlandish or misguided their plans might be.
That makes sense. What other reasons are there for punishing impossible crimes?
Another reason is that attempts to commit crimes, even impossible ones, can still cause fear and disruption.
Okay.
Imagine the panic someone might feel if they're targeted by a voodoo curse,
Oh.
even if they don't believe in such things. The fear and psychological harm are real, even if the threat itself is illusory.
So the law recognizes that the impact of a crime goes beyond just, the actual physical harm.
Exactly.
It's about protecting people's sense of security and well-being, even from threats that might seem irrational or unfounded.
Precisely. And there's also a practical consideration.
Okay.
Sometimes it's difficult to determine with absolute certainty whether a crime was truly impossible.
Right.
What might seem impossible at first glance might turn out to be feasible
Yeah.
under certain circumstances.
Could you give me an example?
Certainly. Imagine someone trying to poison someone with a substance they believe to be deadly.
Okay.
It turns out the substance is harmless, but the intent to kill was there.
Right.
The law doesn't want to create a situation where someone can escape liability simply because their knowledge of poisons was faulty.
So it's better to err on the side of caution and punish the intent, even if the outcome was impossible based on the specific circumstances.
Yeah.
It's about closing potential loopholes and ensuring that people can't exploit technicalities to escape accountability.
Exactly. It's about upholding the integrity of the law and ensuring that justice is served,
Right.
even in those unusual cases where the crime itself might seem absurd or illogical.
This whole concept of impossible crimes really highlights the complexity of criminal law
Yeah, it really does.
and the thought that goes into crafting laws that can encompass every possible scenario.
Right.
Now let's shift gears a bit
Okay.
and talk about the stages of a crime. I remember you mentioned that there's more to it than just committing a crime.
That's right. The revised penal code distinguishes between attempted, frustrated, and consummated felonies,
Okay.
recognizing that criminal acts don't always unfold in a neat and predictable manner.
Okay. I remember we touched on these stages briefly in a previous segment,
Right.
but I'd love to delve a bit deeper.
Of course.
Remind me again what each stage entails.
Let's start with attempted felonies.
Hmm.
An attempted felony occurs when someone begins to execute a crime directly by overt acts,
Okay.
but doesn't succeed in completing the crime for reasons outside their control.
So they've taken concrete steps to commit the crime, but something stops them from finishing it.
Exactly. Imagine someone trying to break into a car,
Okay.
but they're interrupted by a passerby, or they trigger the alarm and run away. They had the intent and took some actions towards committing the crime,
Right.
but they didn't achieve their ultimate goal.
So it's about distinguishing between mere intention and actual action taken towards committing a crime.
Precisely.
What about frustrated felonies?
A frustrated felony occurs when someone performs all the acts necessary to execute the crime, meaning nothing more is needed to complete it, but the crime still doesn't succeed due to causes independent of the perpetrator's will.
So they did everything they could to commit the crime, but something beyond their control prevented them from achieving the desired outcome. Could you give me an example?
Certainly. A classic example is someone shooting someone else with the intention to kill.
Okay.
But the victim survives due to prompt medical attention or a stroke of luck.
Okay.
The perpetrator did everything necessary to carry out the murder,
Right.
but the outcome was thwarted by factors outside their control.
It's like saying they completed all the steps in the recipe for murder, but the final dish didn't turn out as planned, thanks to unforeseen circumstances.
Right.
So the key difference between attempted and frustrated felonies lies in whether or not the perpetrator completed all the necessary actions for the crime to be successful. And consummated felonies are the simplest to understand, right? It's when the crime is successfully completed.
You got it. All the elements of the crime are present, the perpetrator achieved their intended outcome, and there are no mitigating factors that would lessen their liability.
These distinctions are really helpful in understanding how the law breaks down criminal acts and assigns different levels of culpability based on the stage of the crime.
Absolutely.
Now, let's move on to those situations where multiple people are involved in a crime.
Okay.
How does the law handle conspiracy and proposal?
That's where things get really interesting. Conspiracy and proposal involve holding people accountable for their roles in planning or instigating crimes, even if they didn't personally carry out the act itself.
So it's about recognizing that criminal activity often involves collaboration, and that those who plan or encourage crimes are just as culpable as those who physically carry them out. But what's the key difference between conspiracy and proposal?
Conspiracy exists when two or more people agree to commit a crime and decide to carry it out. It's about a shared criminal intent, a partnership in breaking the law.
So it's not just about idly chatting about doing something illegal.
Right.
There has to be a genuine agreement and a plan to act on that agreement.
Exactly. And it's important to note that under Philippine law, conspiracy itself is generally not punishable.
Oh, wow.
Unless there's a specific law that makes it a crime.
Wait, really? So simply agreeing to rob a bank isn't a crime in itself?
That's right, though it might seem counterintuitive.
Yeah.
The law draws a distinction between a thought and an act. Simply talking about committing a crime isn't enough to be held liable.
Right.
There has to be some concrete action taken in furtherance of the conspiracy.
But there are exceptions, right?
Yeah.
Like conspiracy to commit treason, which we talked about earlier.
Precisely. There are specific laws that criminalize certain types of conspiracies, especially those that pose a serious threat to national security.
Okay.
These might include conspiracy to commit treason, rebellion, coup d'etat, sedition, or terrorism.
So it's not just about the agreement itself, but the nature of the crime being planned.
Exactly.
Okay, now what about proposal? How does that differ from conspiracy?
Proposal occurs when someone who has decided to commit a crime suggests it to another person,
Right.
essentially inviting them to join the criminal enterprise. However, unlike conspiracy, proposal is even less likely to be punishable under Philippine law.
Oh, okay.
Unless there's a specific law against it.
So even fewer scenarios where simply suggesting a crime can get you into legal trouble.
Right.
But again, there are those specific laws that criminalize proposals to commit certain serious crimes like treason or terrorism.
Exactly. The law takes a hard line on those offenses, intervening at an earlier stage to prevent those types of crimes from even being planned.
Wow. We've really delved into some fascinating legal territory today. We've explored the philosophical underpinnings of criminal law, the elements of a crime, those intriguing scenarios like impossible crimes, the various stages of a crime, and the distinctions between conspiracy and proposal.
It's been a whirlwind tour through the complexities of the Philippine Revised Penal Code, hasn't it?
It has.
But it's so important to understand these concepts because they shape how we as a society, define, address, and hopefully deter criminal behavior.
Absolutely. It's been an eye-opening experience, and I feel much more informed about this area of law.
Good, I'm glad.
Any final thoughts for our listeners before we wrap up this deep dive?
I encourage everyone to continue exploring the world of law, not just as a set of rules and regulations, but as a reflection of our values, our history, and our ongoing efforts to create a just and equitable society.
Well said. A huge thanks to you for guiding us through this deep dive. Your expertise has been invaluable.
Of course.
And to our listeners, keep those legal documents coming. We're always eager to unravel more mysteries and shed light on this fascinating world of law. Until next time, keep those minds curious and those conversations flowing.